Good afternoon. I will call the Rules Committee meeting to order and would ask only members of the committee to engage your cameras. And as necessary, we will ask guests to come on camera at appropriate times. So would just members of the committee and Attorney Del Campo have your cameras on? Okay. Would Attorney Del Campo, would you please call the roll call, please?
Yes, Your Honor. Your Honor is here. Judge Armada.
Present.
Judge Chaplin, I believe he's on the bench.
Correct.
Judge Green.
Present.
Judge Maturowski.
Present.
Judge McLaughlin.
Here.
Judge Pearson.
Present.
Judge Prats.
Here.
Judge Stewart.
Here.
Thank you.
Thank you. First of all, I'd like to apologize. I neglected to look at my calendar when I was getting dressed this morning, and I thought I was just writing an opinion all day, which is why I do not have a shirt and tie on, and I apologize for that. The first item on our agenda is the approval of the minutes from the December 18th meeting. Is there a motion to approve the minutes?
So moved, Judge Prats.
Is there a second?
Second, Judge Armada.
Thank you. Are there any changes or additions? Attorney Del Campo, anything that we missed?
No, Your Honor.
If there's nothing from any members of the committee, all in favor, please raise your hand. Opposed? That passes unanimously. Ms. Semino, could you please turn off your camera? Thank you. The next item then on our agenda is 2023-008, a proposal regarding pathways. I understand from Judge Diana that he has asked that this be moved till next month because he has ongoing meetings with various stakeholders. Is that correct, Attorney Del Campo?
Yes, Your Honor.
Is there any objection to that? If not, we'll move on to the next item, which is 2023-016, a proposal to amend the practice book to require all attorneys and self-represented parties subject to e-filing requirements to accept service of documents electronically. And Attorney Del Campo, tell me if I'm wrong, but if I'm distilling all of the comments correctly, there's not really any opposition to having this requirement for attorneys who are e-filing, but not for self-represented parties. Is that correct?
Yes, Your Honor. That is correct.
Okay, I'll open up the item then to the members of the committee for any discussion. Any thoughts? Is there, I'm sorry, give me 1 second. Do we have actual formal language, Attorney Del Campo?
We do not, Your Honor.
Yeah, okay. Then we're not voting on anything just yet. With that in mind, then, as I read the comments, Judge Bellis was helping to organize and coordinate this item. Could I ask Attorney Del Campo to work with Judge Bellis to draft up actual language for the committee to consider and vote upon?
Yes, sir.
Is there any objection to that from members of the committee? If not, we will keep moving forward. The next item then is 2023-017, proposal to amend practice book section 25-5B1 concerning automatic orders upon service of the complaint or application in clarity with respect to premarital or postnuptial agreements. We received this proposal from Attorney Von Cohorn and sent it out for comments from Judge Diana and the CBA. I just recently looked at the CBA comments, which expressed strong opposition to the proposal. And if I recall correctly, Judge Diana would support amending the language. But I have concerns at this point, but I'll open it up to members of the committee for discussion.
I would note that the members of the CBA were unanimous in their asking us not to act on this, and their reservations about the same, which says something to me.
It spoke to me loudly as well. Is there any objection to tabling this item? Okay, then we'll table that for that item at this point. Then I would move on to item 2023-018, a proposal for supervision of civil jury selection in every case to curb abuse and delay currently occurring during voir dire in Connecticut. And if there was opposition to the prior item, I suspect it is only exceeded by the opposition to this item. Is there any objection to tabling this item? And let me just say, you know, I think our normal course of affairs caused some confusion. Regardless of what item we get, it has been our history and practice to send it out to the CAJ of whatever the respective division is for comment. As I have gotten feedback on this item, that caused some concern because some individuals thought that this was something that was at the precipice of being approved by the Rules Committee, and I think it created unnecessary confusion. We can continue with our normal practice. We could also perform a more of a gatekeeper function and not even forward some proposals on for comments. So we can discuss that now or whenever we have an appropriate opportunity the next time. But it was not my intention to create consternation among civil judges by forwarding that item for consideration. Did anybody want to mention anything on that aspect of this at this point? Okay, maybe next time somebody sees something that might need a more of a gatekeeping function, we can discuss it next time we have such a proposal. Then the next item is 2023-019, a proposal to amend practice book section 30A-5 to include the requirement that a current predispositional study be provided to the court for a child being placed in probation with residential placement in a secure or staff secure facility and in alignment with the general statutes. I frankly just had an opportunity just today, I apologize, to review Judge Wynne O'Dowd's comments. I think Judge Wynne O'Dowd is with us, but frankly, thank you for joining us, Judge Wynne O'Dowd. Can you, for the next 4 items, can you just say whether you've shared your comments to the committee with Judge Wilkerson Brilliant?
I have. So I provided my proposed amendments to Judge Wilkerson Brilliant, and I've also provided them to the stakeholders, Attorney Renee Semino from the Public Defender's Office, as well as Attorney Duba from the State's Attorney's Office.
Okay, thank you. I have to say I'm not as prepared on this item as I wish I had been, but if members of the committee are more prepared than me, then we can discuss that this first item at this point in time. What's the will of the committee? Judge McLaughlin.
Thank you. I'm happy to discuss it now, but certainly if other members of the committee haven't had an opportunity to review Judge Wynne O'Dowd's comments, I think I just want to know if everyone else is sort of in the same space as yourself, Justice McDonald, before. And that's only because I have some familiarity with the subject area. So I think that's also why I defer to the committee if everybody else is sort of still going through the.
Let me do it this way. I did scan it. I can't say I did it in depth, but let's do it this way. All members who are prepared to discuss this substantively now, could you raise your hand? Okay, then we shall discuss. So who wants to go for it first? First of all, let me ask Judge Wynne O'Dowd if she'd like to provide any context or preliminary statement with respect to this item.
Sure. First, I want to thank the Rules Committee for giving me the opportunity to speak today and provide those proposed amendments, having reviewed them from Judge Volkus and Berlant. Most of these proposals are aimed at the clinical needs of the children and youth that come in on the delinquency side. So that's what's really driving these practice book changes to make sure that they align with both the statute, which is 46B140G, specifically with regards to practice book 30A-5, and also to set forth a very clear procedure to ensure that there's fairness and appropriate placement and an orderly transition for these children and youth into either a residential placement that's staff secure or a secure facility. And then as we get later down the agenda items, for those youth that require a SOLNT evaluation. What we don't want is to have, the practice book can be clearer with regards to the procedure to ensure that kids are coming in there, the clinical needs are being met, and also that they're not jumping the queue when other children have been waiting for these very limited placements. So that's what's really driving these practice book proposals.
Thank you very much. Are there questions for Judge Wynne O'Dowd from members of the committee? Judge Green.
Are the changes supported by the public defenders and the state's attorneys?
So I have Attorney Cimino is here as well as Attorney Duva. We've had informal conversations, so I'll let them speak to their position. But my understanding is there is an agreement, but unless something changed.
So I'm sorry, that's Attorney Cimino and who else?
Attorney Duva.
And okay, so if Attorney Cimino and Attorney Duva could turn on your cameras at this point in time, I'd appreciate that. And since Attorney Cimino came on camera first, I'd ask her to address the committee, and then Attorney Duva. Your mute.
Yes, thank you for giving me this opportunity. We are in support of it with regards to the SOLNT motions. I do believe that there needs to be an orderly process. I think it was actually my case in juvenile court where we had been waiting our turn in the process to get a client who needed services, and another court bypassed the service memo and was able to jump in front of my client. So as with regards to SOLNT, I am in agreement with having those changes. If we're talking about the service memo for locked regions, we have a couple of little areas, I think Attorney Duva and I both, where there are some concerns. Do you want me to go over those?
Attorney Duva.
Thank you, Your Honor. Thank you, everyone, for allowing me to speak. Yes, it's terms of the queuing issue. You have kids that may have been detained waiting for SOLNT, how they're supposed to be, and then somebody comes in and without the proper clinical recommendation, and then gets an order from a court to go to SOLNT, kind of skips the line, and the people that were waiting patiently, kind of got you have to stay and wait longer. So that's not really fair. So that is, I think, a good change. And like Attorney Cimino said, the other thing is in regards to the state's ability or probation's ability and even the court's ability to order a locked regions placement. As everyone knows, that's our ultimate therapeutic or ultimate treatment facility is a locked placement. Same thing, we want people to be able to So what normally happens is there's a clinical consultation, takes about 20 business days to be done. It's usually done by our clinical coordinators. And then the court gets the report and the lawyers get to argue. And then the court decides where the child should go, whether it's the locked placement, whether it's to the staff secured placement, or whether it's a community probation. Our concern was sometimes there's some cases where we would like to be able to have the court be able to order the locked placement. And it's very rare because, as you know, the court can order the locked placement based on the severity of the crime and or with the clinical recommendation. There are times, and Attorney Smee and I actually have a case in New Haven where we have for instance, this child was transferred to the adult court on an automatic transfer, and all the lawyers seem to be in agreement that the disposition should be the locked juvenile setting and not Manson. And if the rules are interpreted or are written where we need a clinical approval or clinical recommendation for that locked juvenile treatment, we're actually doing it to save the kid having to go to Manson. So that was my only concern, is that if we had a case like that with an automatic transfer to adult court, we're trying to have the disposition in juvenile court, but maybe we don't have the clinical recommendation, that we don't get hung up, and then we can't effectuate the disposition in juvenile court, and then the kid ends up in Manson. That was, I think, the only concern that we would like to be able to have the judges have the flexibility. But I understand the reason that the proposal was made is because we don't want to have no clinical recommendation that the child needs a secure either locked placement or a staff secure placement. If that makes any sense.
Thank you. Judge Winodowd, did you care to comment?
Sure. I know Attorney Semino had her hand up, so I didn't know if she wanted to have further comments, that I can comment on both of their positions.
I may have missed that. Did you want to add anything, Attorney Semino?
Yes, we had 3 specific cases where there were robbery ones transferred to adult court. We were able to work out an agreement where the prosecutor allowed a YO for adult court, and we gave them the services that they needed in juvenile court because adult court can't access our services. Thankfully, our 2 clinical consults came back recommending regions, but we have one that we're going to be working on today that we're worried that they're not going to make that recommendation. I mean, I'm going to try my best to lay the foundation at the CRT, but, it's just in those limited situations where, we would be arguing for our worst punishment, which is locked regions, but it's just to avoid and actually get the client out of Manson. And the 2 other clients were both young ladies that were in Niantic for about 6 months that we were able to return back. So sometimes we have really good outcomes, and we're just hoping that this does not put up a barrier to us using the juvenile services.
Thank you. Judge Winodowd.
Sure. So I'll respond to the comments in 2 parts. So I think we jumped ahead because we were looking at the service memorandum for under practice book 30A-8. And I think we jumped to SOLNET, which is practice book 31A-14. So I think sounds like from Attorney Duva and Attorney Semino that there was no objection to the evaluation requirement for a 30-day SOLNET evaluation.
Yes, correct.
And I'm sorry, forgive me, I was trying to follow the bouncing ball. Is that 30A-8?
31A-14.
That's where the concern is.
The concern is with 30A-8 regarding the service memorandum.
Thank you.
I'm sorry, 30A-5.
Yeah.
Thank you. Did you have any other comments, Judge Winodowd?
So I do. So as I said in the beginning, and I hear what Attorney Duva and Attorney Semino are saying with regards to the service memorandum. The result is it's the same result that we would have if SOLNET, if we skipped, that you would have, number one, I don't know if a judge was to order placement directly at a residential facility, whether it's secure or staff secure, whether or not either one of those is appropriate for the youth before us without the clinical recommendation. The statute also provides that the length of time that the residential placement takes place is based on their clinical needs. And without that evaluation, we don't know exactly how long they should or should not be there, even if placement is ultimately being recommended. So this is the first I've heard about some of the concerns that they have. It sounds like they're far and few between with the cases, because most of the cases that come through, I think the parties know that it's going to be, with the clinical consult, it's going to be a recommendation for either a staff secure or secure facility. I think the fallback from what Attorney Duva and Attorney Cimino is saying is that there may be that small window where we need to get those kids in there because they're trying to avoid something on the adult criminal side if the case is transferred, because the services may not be the same because they don't have those same services with regards to a facility for the youth that we have here on the juvenile side.
Thank you, Judge Prats.
Thank you. So just to be clear, this 31A14 subsection C, where is STOLNet? Because I did, juvenile many years ago. I'm not familiar with STOLNet per se. When I was doing juvenile work, we used to have the clinical coordinators. I do have some concern that the only way the person can be committed to this place is through a clinical coordinator. I know like in Waterbury, we didn't have one or available one every day. Do all the courts have clinical coordinators every day available to them in juvenile court?
So there's 17 clinical, I believe it's 17 clinical coordinators across the state. So if there is a request for a SOLNet evaluation to be done, it could be assigned to any one of those clinical coordinators. So not necessarily the one that's physically housed in your courthouse. So the clinical coordinator would do the assessment to determine whether or not a 30-day SOLNet evaluation is necessary. So I think, Judge Prats, maybe when you were practicing, it might have been Riverview, but now it's SOLNet.
Yes, I was just going to ask you, where is STOLNet?
Where is STOLNet? Windsor?
In Windsor. So they don't use Riverview anymore.
No.
And so this is for, I'm not sure the purpose of this evaluation. When we use clinical coordinators, it was more for a child that's in crisis, whether or not they should go like a pre to the hospital by emergency. So this is to put someone in a residential or a confined setting for 30 days because mentally, it's not a competency, right?
So it's not a competency. So the 30-day evaluation is SOLNet is for evaluation purposes. So you may have a child that's presenting with differential diagnosis. And so we're trying to figure out which one is the diagnosis really driving some of these behaviors in order to get the appropriate treatment for the child. But the 30 days is not to send the child there for treatment purposes. It's for evaluation purposes to determine then what would be the next step, which would be the most appropriate treatment intervention, a level of treatment intervention.
And the purpose to make the changes to have the clinical coordinators be gatekeepers versus judges ordering and then upsetting like maybe priority in terms of the limited number that is permitted or allowed in this facility. Okay. Thank you.
Any other questions from members of the committee? I will, Judge McLaughlin.
I just wanted to sort of clarify Attorney Duva and Attorney Cimino, their concerns with respect to residential placement. So is the concern that the proposed language somehow, or I'll say it this way, is it your, excuse me, I guess, is it your desire to have some portion of that practice book rule give discretion to the courts in the event that there's extenuating circumstances like the case you were just talking about for the judges to consider secure, staff secured residential? Is that the concern with the new proposed language?
Attorney Duva.
Thank you. Yes, I just wanted to be able to, for the judges to be able to see that in a situation like we proposed, even if it's not, and I don't know how all the clinics will come out, but in that situation, if the clinic didn't come out and recommend the residential treatment, that, you know, it's better to go to the juvenile residential program than Manson, and not to let the lack of that recommendation put a kid in Manson that could, you know, would probably do better in the juvenile setting. So I think, yeah, Judge McLaughlin, that's a good suggestion, maybe to be able to put some language in that if there's circumstances call for it, that a court can, you know, override that. And I apologize to Judge Nguyen. This literally just came up. She's asked us a couple of times about things that we could think can go wrong, and this really doesn't happen a whole lot, but this is a situation that, you know, just happened to come up because the case is on tomorrow, and we're like, oh, this is exactly what, you know, we want to prevent, to not, you know, be able to do a creative disposition.
Attorney Semino.
Yes, I know Judge Nguyen added some language about some of our concerns where there is an, I think she added a number where it indicates that the child or the child's attorney can make it any argument and use any clinical information that they have. So for this particular case, I think our concern is if the clinical coordinator doesn't recommend regions, what am I going to do? With her proposed language, I can try to put in my own expert in front of the judge to make the argument that I think he should go to locked regions, which is not usually something the public defender does, but based upon these circumstances. So I think there was some language included in there that makes me feel a little better, but this unique situation doesn't come up very often. For me, it's been, you know, 3 times in the last, it's 10 years.
Judge Winnow Dowd.
So to Attorney Semino's point, they did raise this concern. And so I did put in there subsection E, giving the other parties an opportunity to provide an independent evaluation to the court in its consideration. So I think that was kind of the compromise that we had discussed, so that it wouldn't just be a rule out that this is the only information the judge could rely on. But that service memorandum and the clinical consult is really critical, because that's really going to drive what that child is going to receive in one of these facilities. And also, going back to my opening statements, whether or not that child is appropriate for that placement or not. There's, you know, in the case that Attorney Duva may be speaking to, that a child that is looking at you know, being transferred to the adult court and then coming back here, those are very serious offenses that are being transferred to the adult court. So, I mean, that conduct needs to be looked at, and whether or not a residential placement is appropriate with other individuals as well. And so to not have that information and to just make the decision without any of those clinical recommendations, I think would be doing a disservice to the procedure that's in place, and a disservice to the children or youth that are going through the process and having that evaluation done, to have all that information before that decision's being made.
So I will forthrightly acknowledge that this is a area of the law that I am not an expert in, and this is a level of technicality that I am not comfortable with. So I'm looking for some guidance from somebody more knowledgeable than me about how we should proceed at this point. Crickets. Judge Winnow Dowd, how would you, Judge Green?
Well, it sounds like there's consensus on, is it 31A-14, right? Everybody agrees that that's an appropriate change. So maybe we start there.
That's what,
and the others may need some tweaking or further discussion, but it seems like we can support that.
Okay, so this was addressed as a package, but right now, taking the lead from Judge Green, we would be talking about item 2023-021, which deals with the changes to practice book section 31A-14. I too heard that there was consensus around the proposed changes with that item. Is there? I like nodding heads. That's great. Okay. With nodding heads, is there a motion to approve that item?
I'll move.
I have a question.
Okay, one second. So who moved it? Judge Green. Who seconded it? Judge McLaughlin. Okay, so Judge Wynn O'Dowd, you can address 31A-14.
So I just wanted to clarify that 31A-14, what's being voted on is, so I made changes to Judge Wilkerson Berlion's original proposal. So I just want to be clear which ones are being voted on, Judge Wilkerson Berlion's or the ones that my proposed amendments.
You know, it was your amendments that were in my head, but I failed to articulate that. So I apologize and I appreciate that clarification. The language we're talking about is included in Judge Wynn O'Dowd's letter dated January 19, 2024 for that item with respect to practice book 31A-14. Judge McLaughlin.
Also, I was just looking again at Judge Wynn O'Dowd's amendments, practice book section 26-1. It seems to me that perhaps that's the one with the definitional changes for the practice book. That may have to go first, potentially. I think maybe because I know it impacts 31A-14. I wasn't sure if we wanted to discuss that.
Well, let's just for convenience, we don't necessarily have to take that one up first, but your point is well taken. We would have to address that as well, but since I have a motion on this item, let's deal with that first. Is there any discussion from members of the committee with respect to 31A-14? Judge Armada.
I just want to be clear that Judge Wynn O'Dowd, as the Chief Administrative Judge for Juvenile Matters, is in favor of this amendment to 31A-14. Yes?
Yes, based on my proposed amendments.
Right. Okay. Is there anything further? If not, with respect to the language proposed by Judge Wynn O'Dowd, all in favor, please raise your hand. Opposed? That passes unanimously. Okay, so but to then take up Judge McLaughlin's thoughtful suggestion, why don't we go back to, oh no, it's actually the next item, 2023-022, the proposal to amend practice book section 26-1 for definitions. Well, that impacts 31A-14, 38.5 and 38.82. Let me open it up to Judge Wynn O'Dowd on that item.
So those 26-1 are definitional terms, as Judge McLaughlin pointed out. So these are terms that we've added based on the language that the practice book that was just approved and passed 31A-14 to include the definition of a clinical coordinator, clinical consultation, forensic clinical assessment, as well as a service memorandum. And those are all terms and documents that are being currently used in the juvenile court. So this is not new language that we're creating at this point. It's someone sitting in juvenile court is versed in knowing that a clinical consultation needs to be asked in order for a forensic clinical assessment to be done. And then the service memorandum comes to court, which is the written report. So these terms just codify the procedure that's already in the court right now.
So please just educate me. If we approve the definitional changes in 26-1, is that contingent on us making the adjustments in 30A-5 and 30A-8 too, or those definitions would have other applications?
Other applications to other sections?
Correct.
Those would be applicable to these sections that were being proposed today.
No, maybe I wasn't clear. I may be stumbling on myself here. Do the definitional changes in 26-1 presuppose the adoption of the changes in 38.5 and 38-8?
Presuppose the changes.
I guess what I'm saying is should we hold off on those changes until we have any resolution of the language for 30A-5 and 30A-8? Or is it independent? Maybe Judge Stewart knows where I'm going.
I think they can be approved without approving practice book 30A-5 because it's not the and Attorney Cimino, Attorney Duva can correct me if I'm wrong. It's not the definitions that we disagree upon.
Okay.
I think it's what should be the specific process and procedure.
Okay, I think that answers my question, but Attorney Duva, did you have anything?
Just wanted to add, yes, the definitions aren't going to change. I think the committee can freely vote on the definition section. It's not going to change the other parts we're discussing.
Okay, that's the green light I was looking for. Okay, then with respect to the proposed item 2023-022, the proposed amended changes to the definitional language in 26-1, is there a motion to approve? Judge Pratt?
Yes, I'll move to amend the practice book as proposed by Judge Dowd on the proposal in the language that she submitted for today's meeting.
Thank you. Is there a second?
I'll second Judge Armada.
Thank you, Judge Armada, with an honorable mention to Judge Pearson as well. Is there any discussion from members of the committee on this item then? If not, all in favor, please raise your hand. Opposed? That passes unanimously. Okay. As I'm crawling my way through an area of the law I don't have expertise with, can I make a recommendation that we pass 2023-19 and 2023-20 and afford Judge Winnow Dowd just one more opportunity to sit down with Attorney Cimino and Attorney Duva and any other stakeholders to try and iron out some final proposals? Is that what I was hearing was warranted, or did anybody have an opposing viewpoint? Judge Prats.
I just have a question still. So if we amend the practice book to be aligned with the statute, the way I recall, a PDS is like RPSI. Why is there concern about charges being like split between the regular court or juvenile court? Sometimes the juvenile court, the prosecutor has the discretion to keep something so that they can still work on the case. I'm not sure why this requirement is affecting that.
Judge
Or
Winnow
I'm
Dowd.
misunderstanding Attorney Cimino's concern.
Judge Winnow Dowd.
I don't understand. Well, I'll let just Attorney Cimino because she can probably articulate more her concern when the cases are transferred to adult court. So once the case is transferred from juvenile to adult court.
How are you, Renee? I don't know if you remember me from years ago.
How are you? How are you?
So how is it that the requiring a PDS and making it that already the Connecticut statute requires the PDS if someone's going to residential or secure facility? How does that impact if a case is bifurcated? So a case can be, part of the case can be transferred and some of it stay. I'm not sure if I understand your concern, how this affects that.
The PDS is fine, and I do agree that we need the PDS. It's the clinical consult that can be the gatekeeper. So if the service memorandum says, no, we don't want him at Regions, and they might have some legitimate reason, like Judge Winnow Dowd is stating, that we don't want him at the locked Regions facility. It's going to be an uphill battle for whoever's the attorney, where we're then making an argument against the clinical consult.
So the clinical consult deals more with the mental capacity of the child, but they also make recommendations. And your concern is that the recommendations after the 30-day study may clash with a PDS or what you're trying to accomplish for the child?
Yeah, it's a 30-day would be different. So this would be, I have a kid in Manson and I'm working out charges when we're trying to get them to go to regions. Everyone agrees, the prosecutor, the public defender, we're hopefully that the judge is going to get on board. If the clinical consult says no, they're almost a little bit like a gatekeeper to get into regions. Again, Judge Wynne O'Dowd was kind enough to include that language, so I can still make arguments to the court and say, you know, we don't agree with the clinical consult. Here's our own expert, which we did hire an expert in this case, so I would be able to put him on and he'd be able to testify. So it's not the PDS. The clinical consult seems to be a gatekeeper to regions and sometimes the SolNet. Again, you could still make arguments, and the judge they do have the ultimate say.
All right, thank you.
Judge Wynne O'Dowd, looking for some guidance from you. How would you like the committee to proceed at this point?
Sure. So with regards to practice book 38-5, I'd be more than happy to sit with Attorney Cimino and Attorney Duba to kind of flesh out, you know, those concerns that they just described in those limited situations. And maybe we can come back next month. I think it's a very narrow issue because I don't think it doesn't sound like there's a disagreement that practice book should align with the statute requiring the PDS before a probation with placement is ordered, whether it's secure or not secure or staff secure facility. I think it's that latter part with regards to the service memorandum and the clinical consult that needs some more discussion. So I'd be happy to discuss with counsel that issue. As to, I think there's one left. I know I'm jumping ahead. Practice book 30A-8, that's just to include the service memorandum in the court materials that are considered confidential, because right now when a service memorandum is done, it's put in the file, but that's not included in the list of documents that are considered confidential that requires the court order to be released and reproduced.
Okay.
So I think 30-A can be voted on. I think it just leaves then 30A-5 for attorneys Duva and Cimino and I to discuss that latter part.
I think I'm following the bouncing ball at this point, I think. Okay, so Attorney Duva, you had your hand up. Does that sound good that we would proceed with 30A-8 and give you, Attorney Cimino and Judge Wynne O'Dowd, another month to work on 30A-5?
Yes, I just wanted to agree. I don't think there's a disagreement. I think it's just the way it's worded. I think we can work things out.
Okay. And before I go any further down this rabbit hole, I want to make sure that Attorney Del Campo is clear what we've done so far, because there have been a lot of moving parts. We've approved 2023-021 and 022. We're now going to take up item 2023-021, and we're going to table, or we're going to pass for a month item 2023-019. So with that having been said, is there a motion to approve 2023-020 with respect to practice book section 38-8 using the proposed language from Judge Wynne O'Dowd?
So moved.
Is there a second?
Second.
Second. Is there any discussion? If there's no further discussion, Judge McLaughlin.
I just had one question on 30A-8. So on said section B, which is where the amendment is with it adds the service memorandum, but just for clarification, are there other documents that would be in the file that are not in this list? Because I think when I read it initially, my question was, would it make more sense if we said including but not limited to and list all of those? Or is this the exclusive list of documents that would be considered confidential that could be in the court record? Does that make sense? So I think that was my only question, if this is actually more limiting than we wanted it to be. Because the way I read it after we changed it would be that it's only those documents listed unless we said including but not limited to.
Judge Wynne O'Dowd.
Sure. So I was combing through, Judge McLaughlin, the documents and trying to think which ones would fall in there, and contemplating also whether we put including but not limited to. I think if we put included but not limited to, doesn't really put the parties on notice as to what should and should not go, rather than identifying specifically what we know is in the juvenile file on the delinquency side and making sure that those remain confidential. So to the extent that another document or court report could be included for a future amendment, you know, it's probably going to be left open. But from what I was looking at, this is kind of all the documents that are in there that are typically in there that should remain confidential.
Thank you.
Are there any further questions or discussion on this item? If not, all in favor, please raise your hand. Opposed? That passes unanimously. Okay, and then Judge Wynn O'Dowd, before I give you our gratitude for your guidance in this area, is 1 month sufficient on Practice Books 30A-5 for you? Understanding we probably only have 2 more meetings before the end of our business being discussed for passage of new items.
Sure, I think 1 month is enough time because I don't think we're so far apart. Based on the comments that I've heard today, I think it's more just maybe tweaking some of the language if we can agree upon it. But I don't think 1 month is. I think 1 month is plenty of time.
Okay, great. So again, with my gratitude, we'll put this item over for 1 month. I will say we got a lot of this material just in the last day or two. As I confessed earlier, this is not my strong suit. So the more time you can get any proposed language to, at least to me, but probably to other members of the committee as well, it would be helpful to let me digest it and not display my ignorance in a public forum.
I'll try to get that meeting set up in the next week.
Thank you very much.
You're welcome.
Okay, the next item then is 2023-023. It's a proposal to adopt a new rule with respect to detailed pretrial notice of an intent to present prior uncharged sexual misconduct. I thought we had sent this to Judge Gold for his comments. Is that correct, Attorney Del Campo?
Yes, Your Honor. He is here today. Actually, I believe he wants to address the committee. He didn't. There are no written comments, but he is here.
Okay. No, happy to have oral comments from Judge Gold. Thank you for joining us, Judge Gold.
No, and thank you, Justice McDonald. I know, though, also present, I think, in the participants is the Attorney Fisher, who I think actually submitted this to you. Did you want to hear from her first? I saw. I don't see her name now, but it was here.
I'm always happy to see Attorney Fisher. We did hear from her briefly last month, but Attorney Fisher, if you care to engage your camera, we'd be happy to have you join us on this item. And you're muted.
Hi, thank you so much. Good afternoon, everyone. I wasn't aware that I would be addressing the committee. I'm happy to address it further, to go on at length about what I believe to be the merits of this request, but I think it's time to hear from you, Judge Gold.
All right. Well, thank you. I'll offer a few comments if I could, please. First of all, I was not provided with any actual proposed rule. So I heard earlier the chair say that there would be a rule proposed and then the actual language of it would be subject to some discussion. I would hope that that be done in this case as well. I would also recommend that stakeholders, both on the state's attorney side and maybe on the defense side as well, are consulted as that rule is developed. More broadly, I want to offer a couple of comments, if I could, so that the Rules Committee understands, I think, what I see as some uncertainty as to what such a rule would cover. In the maybe the stereotypical situation of what we call prior uncharged sexual misconduct, the state might seek to introduce testimony from a victim who is not the victim in the charged offense. Most typically, this is going to come up in child sex abuse cases to prove the offenders, or in an effort to prove the offender's propensity for sexual deviance of this nature. And I certainly agree that the defense should know in advance of the trial, so as not to be ambushed, that there would be that offer from the state. And I will say, in my many years of practice, both on the prosecution side and now as a judge, I am not aware of any case in which this has been sprung on a defense attorney at the last minute. I think the defense attorneys are made aware by the state of the state's intention to offer another complainant. But prior uncharged sexual misconduct can also be viewed to cover something in addition to another victim, but also to cover non-charged behaviors committed against the victim of the charged offense. So if I could offer just an example, if a child reports to having been forced to engage in sexual intercourse with an uncle, the child might report that in the months prior to that charged offense occurring, the child was subjected to other misbehavior of the uncle. The child might say, for example, well, my uncle used to always make me sit on his lap and he would touch me. Now, that might not be the charged crime if the state is only charging the actual acts of intercourse that took place a month later. But if the child is going to be describing these earlier behaviors, that too could be seen as prior uncharged sexual misconduct. And I don't feel that that is something that needs to be disclosed in a written notice if it is contained in the child's statement to the police to begin with, which the defense attorney does have. So I'm just throwing this out as an example of the breadth of this phrase, prior uncharged sexual misconduct. It's one thing to say that the defense should be on notice of another victim coming forward. I'm less certain that that's appropriate if it just involves other behaviors committed against the victim of the charged offense. So I would, again, like to see what the proposed rule is, but I think that the committee should be aware of this concern that I have. I'd ask you to consider it. Secondly, I'd like to mention that this rule comes out, or this proposal for a rule comes out of a case that was decided a couple of months ago by the Supreme Court, and it's State versus Samuel U. At 348 Connecticut 304. And I know that Attorney Fisher was the assigned counsel who represented Samuel U. I know a little bit about this case only because I was the trial judge on it. And there is a great deal of discussion in a concurring opinion written by Justice Eckert, but joined by Justice McDonald, which talks about the fact that there was other crimes evidence in that case which wasn't sufficiently well detailed or defined, and unfortunately, meaning no disrespect to Attorney Fisher, but the defense attorney in this case had a full understanding of what had taken, who this other crime's victim was, and had that notice 8 months before the trial, as is reported in the majority opinion. I bring that up only because there is in the concurring opinion a great deal of discussion about that this notice must include a detailed description of the other crime's behavior. And I would urge the committee to be very careful in requiring that, because it is most frequently going to be testimony from a child. And we don't really even require in the charged offense for there to be a detailed description. And it seems odd to me that we would require that when it regards other crimes evidence. So I am concerned about this detail, the word detailed, which if you look at the concurring opinion, it's mentioned there. I'm concerned about what might be covered in the phrase prior uncharged sexual misconduct. And as a notice requirement, I'm concerned that the failure to comply with it would lead to a requirement that the evidence be excluded. And it, in my view, would be inappropriate to do so, especially when the defense attorney had actual notice of it. So if the committee feels necessary to pass a rule, I would, in addition to the concerns I've already expressed, ask that there be something that provided that for good cause shown, the failure to provide formal notice could be deemed not a sufficient basis to exclude the evidence if the court was persuaded the defense had actual notice of the information. Those are some of my thoughts, and I thank you for considering them.
Thank you. No, you obviously are correct. There's no proposed language. I think what we were doing was to start by allowing you as the Chief Administrative Judge of the Criminal Division to frame the language and to frame the context for the proposal. But if the preference would be for you to respond to language rather than to have you draft it, I'm certain we can get proposed language for your consideration. I would note that there are many other states that have proposals or rules in place with respect to this. The federal rules have a very detailed rule. They included it in their rules of evidence. There has been some speculation about whether this is a issue that's more appropriate for the Rules Committee or for the Evidence Committee. My personal preference was to have this originate in the Rules Committee because it is more of a, in my view, more of a procedural issue of timing and content of disclosures as opposed to an evidentiary issue as other states have taken it up. And frankly, I'd rather have the input of more judges than just how the evidence code is amended. That's why I thought this would be the more appropriate forum to have the discussion. I will be happy to get proposed language. Frankly, it may look very similar to the federal rule that exists and avoids some of the language that you've articulated as a source of concern for you. It doesn't say detailed. It doesn't, it doesn't. But I will say that regardless of whether or not there's been a history of problems, it does seem that this area of the law would scream out for a clear rule about what prosecutors' obligations are, and because they don't want to run afoul of anybody's rights. I do know that Attorney Lawler has his hand up. I'm assuming it's on this item. Attorney Fisher also has her hand up. So at this point, with the indulgence of the members of the committee, I'd like to hear from Attorney Lawler and Attorney Fisher, I assume in response to Judge Gold's comments.
Thank you, Justice McDonald. Yes, I'm very happy that Judge Gold went first, because I think he echoed many of the comments that have been presented when I shared this concept with the state's attorneys when we've been given notice of this. I do note that the state's attorneys in concept are in favor generally of notice requirement in this particular area, given some of the concerns that you previously shared and are included in that opinion. But we do share some of the same concerns that Judge Gold does with how it actually looks. So I think we would be interested in seeing it in written form. And one further area that was that I just wanted to express along with those is just the timing of when notice must be performed. And as it's phrased in what we received earlier, it says 45 days prior to trial. And I think in many courthouses, trials are not scheduled that far in advance. So there's really no way to know when making any sort of a disclosure that it's 45 days prior to trial, just because most trials don't get that firm trial date that far out. So perhaps if there was a rule that was required, that it just be that disclosure would be required on a schedule as set by the trial court. I think that perhaps that would put everyone on notice as to when that would be required. And I would just echo Judge Gold's comments, regarding, I see that it's not covered by a rule, but in my understanding and in my experience, these types of issues normally are disclosed much earlier in the trial, similar to what happened in this particular case. 8 months out, I would think is, that sounds about standard. So.
Well, to be fair, there's a reference, I'm not trying to litigate the case. There is a reference in that case to a docket number for a case where the file had already been destroyed years earlier. So all you had was a docket number with no substance behind it. So, I think I was happy to try to, could everybody make sure that they have their microphones muted if you're not addressing the committee? So if people would prefer to have proposed language circulated rather than given an opportunity to draft it yourselves, I'm happy to accommodate that. If the state's attorneys are interested in sitting down with the public defenders or maybe the criminal defense bar and trying to craft something, we always encourage people to be the masters of their own destiny and propose compromise language that you've had your own hand in. If not, we can do it in a more formal way and have language circulated. So I guess I would ask Attorney Lawler, would you care to try to sit with the public defenders and other stakeholders to draft something, or would you like us to create something and circulate it to you?
You can do it however Your Honor wishes. I think that we'd be happy to assist. If your general idea on this or counsel's general idea on this is something patterned after the current federal rule of practice, we could use that as a starting point and then try and see if we can come up with something that works. But if you'd rather create something on your own and then just share it with us for comment, we can do it that way as well.
So I will open this up to members of the committee, obviously, but in my tenure in this committee, we try to allow the stakeholders who are closest to an issue have a heavy hand in helping formulate a proposal so that if consensus can be reached, it's better for the people who have to live with the consensus, and it's frankly more efficient for members of this committee. But I would put out there for comment by members of the committee that I would suggest that the Office of the Chief State's Attorney and the Office of the Chief Public Defender with the Criminal Defense Bar sit down and try to craft a proposal for the consideration of the members of the committee. I'll open it to members of the committee for comment. Let's see if anybody has comments first, and then Judge Gold.
If I may, Justice McDonald, that suggestion seems to make a lot of sense to me and is in keeping with this committee's tradition in terms of approaching rule changes. So I think it would be most helpful if Attorney Lawler and other stakeholders got together and submitted, or try to come up with something they can agree with that they can submit to the committee for our consideration and for further comment.
Thank you, Judge Armada.
I would also welcome that if they come up with language together, but they have a disagreement, that they would be allowed to submit supplemental letters. Although we agreed to this from the public defender's point of view, we've got concerns about X, Y, and Z, or the state's attorney could comment separately. So we're seeing what they've worked on and helping them get to a consensus, but understanding that they still might have different viewpoints that we should consider before we pass the rule.
Yeah, I certainly agree. And I mean, they can do it however they want. There is a national standard that works for the entire country. That might be a beginning framework. At least it works for the federal system to begin your discussions. But Judge Gold, would you care to comment?
No, just to agree with you. I think it's a good idea to say that if the public defenders and the prosecutors and the defense bar can work together to propose something, I think that would most likely lead to a fair rule for all that have to live with it.
Okay, does that sound, can you carry that forward, Attorney Lawler, and coordinate that with the Chief Public Defender's Office and the Criminal Defense Bar?
Certainly, Your Honor.
All right. Judge Gold, did you just raise your hand again? You went up, went down.
Yeah, sorry. I just meant to say one other thing. I would just ask Attorney Lawler and others that are considering this to just keep in mind the statutory provisions that might preclude identifying the victims of these assaults. Under 5486E, there has to be some way to ensure that these individuals who are being identified in the notice aren't identifiable, because that might run afoul of 5486E's requirement that not happen. So that's all.
Yes, that was raised by one of the state's attorneys earlier today, so appreciate that. Yes, we will incorporate that as well.
Okay, I don't know if we'll have anything substantive to talk about next month, but at least let's report back next month to find out where we are in your discussions with the other stakeholders. Okay, Attorney Lawler?
Yes, sir. Thank you.
Thank you. Next item is 2023-024, proposal to amend practice book section 2-85 concerning the bar application fee. Attorney Del Campo, would we be just sending this out to the bar examining committee for their comments, or anybody else?
Bar examining, yes. Attorney Harrington is here if you want to hear from her, but at least her sections of the attorney regulation section of legal services.
Attorney Harrington. Sorry, I didn't see your initials there in the audience. Happy to have you here, and any comments that you have on this subject.
Thank you, Your Honor. I also have Lisa Valco, who's the director of the Bar Examining Committee, is also logged on. This is the first we had notice of this was last Thursday, and we would obviously love the opportunity to bring it to the committee for their consideration before giving a position on it.
I was going to say, maybe I can ask you, we may or may not be serving a more gatekeeping function. Do you think that this subject is something worthy of consideration by the Bar Examining Committee?
Not without, Your Honor, to speak completely frankly, without any authority. This is simply just a request. There was no basis listed in the email, no reason given that they're seeking this. Quite frankly, we don't. We are self-funded. The committee has to pay for the sites, the proctors, the graders. There's reason that we have fees for the different applications. We have, in the recent past, as Your Honor probably remembers, expanded the fee waiver. If people withdraw from the exam, we've expanded that so that applicants can get much more of a fee waiver for future exams. But at this time, I've been with the committee since 2008, and we haven't had fee waivers. And what I know of other jurisdictions is very few. I would have to update the data on that, but very few offer any type of a complete fee waiver.
Why don't we do this before it, and again, if anybody disagrees, please jump right in. Before we create a whole lot of work for a whole lot of people, maybe I could ask you, Attorney Harrington, to reach out to this proponent and probe a little bit more about what the concern is. Maybe it's a personal bad experience, maybe it's something more systemic, and do a little cultivating of the issue first before we are in search of a solution to a problem that we're not certain of.
I would be happy to do that. I do note he's on and has raised his hand if Your Honor wanted to hear from him.
I'd rather not do it right now. I appreciate it. I'd rather have, you could probably have a more thoughtful and complete discussion offline and report back to us maybe next month. Does that sound good to members of the committee? Okay. But I do appreciate you both being available to the committee today. The next item then is 2024-001, proposal regarding the principles of professionalism. This is the first time this item has been given to us. I've looked over the materials. There's a lot to commend the materials. I'm not entirely certain that it's something that needs to go into our rules, but and frankly, in part because it deals with almost exclusively litigation-focused activities, as opposed to all the other attorneys out there who conduct themselves in areas outside of litigation. But I would, at a minimum, suggest that we ask this to be referred out to both the professional discipline section of the Bar Association and there's also a separate professionalism committee of the Bar Association for their comments and suggestions. Is anybody opposed to that? Okay, is there any other stakeholder? Judge Armada is always good at watching my back on this. Anybody else who should be solicited on this?
I think perhaps, Your Honor, the Chief Disciplinary Counsel and Statewide Bar Counsel's office.
That's fine. They may not have any comments, but at least they will have been given the opportunity.
Right. Thanks.
Okay. All right. If there's no other recommendations on that subject, I'll accept a motion to adjourn. Moved by Judge Stewart and seconded by Judge Prats. All in favor, please raise your hand. All right, we stand adjourned. I appreciate everybody's time today. Take care.